Right now on Law&Crime Report. A member of the Breonna Taylor jury who indicted Brett Hankinson for wanton endangerment is speaking up, saying that they were not presented with homicide charges. Plus, Jamal Khashoggi's fiancée is suing Saudi Arabia's crown prince and everyone else that she says conspired to carry out the journalist's brutal assassination. And later, Ghislaine Maxwell loses the fight to keep her deposition transcript secret. We'll break down what that means for her federal case. This is the Law&Crime Report, diving into true crime and all legal stories making headlines. Good afternoon, I'm your host, Brian Buckmire, here at the Law&Crime Report. We begin the report with the breaking news that came out just yesterday about Breonna Taylor's grand jury being able to break that silence and speak about the presentation there in the grand jury. But let's first go back and compare and contrast what Attorney General Daniel Cameron said about his presentation before we heard from the grand juror.
Our team walked them through every homicide offense and also presented all of the information that was available to the grand jury. And then the grand jury was ultimately the one that made the decision about indicting Detective Hankinson for wanton endangerment. I think that in terms of what happened the wee hours of March 13th, in terms of that particular or specific date and what happened that night in the apartment, I think it is unlikely that there will be any additional prosecutions that come from that event itself.
All right, so let's bring in our guest to talk more about this. I'm joined with a great cast of guests, as always. We've got Jonna, Spilbor, as well as Kirk Burkhalter. Sorry, Kirk. I've said your name 1,000,001 times. And Mike Koribanics. Thank you all for joining us today. Now, let's start off with you, Mike. It seems like we're hearing two different stories, one from the Attorney General and one from this grand juror who has not been made public as yet. We don't know who this person is, but I'm hearing a tale of two stories. What are you hearing?
I'm hearing major disappointment in how this process was handled. I credit the grand juror who knew enough to come forward and say there is something wrong with this process. And it really, I think, hurts this prosecutor's credibility because there was a word he used in the press conference that we just heard that really should have sprung up when he said evidence available. That sort of seemed to me to be, now in the context of what we're learning, is that they were quite selective in what they showed the grand jury when the grand jury should see it all and then make their decision. This is disturbing to me.
Yeah, this didn't sit well. Jonna, as you heard this, so we've had this grand jury come out. I'm going to read a statement in a minute, but I want to get your opinion first. It didn't seem to really square with at least my understanding of how grand jury presentations are typically done. This seemed to be very unique in that the Attorney General gave them what the Attorney General wanted to give them and didn't really give them an opportunity to explore other avenues, that being homicide, justification, or any other potential charges. Does that really make sense with you?
It doesn't make sense if that's in fact what happened. I mean, we have to remember, what do we have here? We have one anonymous grand juror who's coming out with a set of circumstances that he or she feels happened or didn't happen. And we really haven't heard from anybody else whether that is going to be corroborated or justified or what have you. We also have to keep in mind, and listen, I may be playing devil's advocate here, the prosecution didn't have to present this to a grand jury at all. They chose to, in order to make sure that all possible avenues were going to be fettered out. They did. The grand jury came back. It's supposed to remain secret. So I'm not convinced yet that there was something nefarious going on here.
All right, so we're gonna need a little bit more. Let's actually look at the statement from the grand juror and what they said before I bring in Kirk to get his opinion. Basically what the grand juror said is the grand jury was not presented any charges other than the 3 wanton endangerment charges against the Detective Hankinson. The grand jury did not have homicide offenses explained to them. The grand jury never heard anything about those laws of self-defense or justification. That was never explained either. Questions were asked about additional charges, and the grand jury was told there would be none because the prosecutors didn't feel they could make them stick. The grand jury didn't agree that certain actions were justified, nor did it decide that the indictment should be the only charges in the Breonna Taylor case. Now, Kirk, I hear what Jonna is saying. This isn't corroborated. This is one person, a mysterious, anonymous individual. But as I understand grand juries, as a public defender, if an individual has those questions in the grand jury, are those questions not supposed to be answered so that the grand jury can come to the decision rather than the presenter of the information?
Certainly, those questions should be answered. Now, what that answer should be is, wildly different. Answer may be you are not to consider that, or that's not what we're considering, and so forth. But those questions can be asked and they should be answered. What's very interesting to me is we heard the prosecutor state that the grand jurors considered all homicide charges, all. And I'm always a little suspicious whenever you hear a lawyer use very definitive language like all, always, and so forth. But all homicide charges. And then we have this directly conflicting information that they only considered the wanton homicide charges. So which is true, we don't know. Clearly, these questions, well, I won't say clearly, the grand jurors certainly claiming that these questions were presented. I would love to know what the response was. I would dare to say that we may never know, unfortunately.
And so, Mike, I'm going to field this question to you because as I heard this yesterday, I kind of sat there with my wife and I was like, I don't know if he did anything legally wrong or if there's any legal way of fixing this. Because as Jonna had said, he didn't have to present this to the grand jury. He chose to do so. And when a prosecutor chooses to do so, they can do so really in any way they want. Now, can we Monday morning quarterback and say, hey, you told us you did X. It appears, or at least sounds now, that you did Y. Is there any recourse, or can he just come out and say, I presented what I presented, and they came up with what they came up with?
Well, there's a lot of recourse, I feel. Number one is I'm not so familiar with Kentucky, but I know in New Jersey there is a Victims of Violent Crimes Rights Act. Victims have a lot of input in New Jersey, and I think that's a sweeping trend across the nation. It's troubling. Something pricked up my ears about this case and about this presentment when the grand jury transcripts were released redacted and they didn't have the jury charges and the readings of the law in them. There's nothing confidential about the law. And that was something that made me wonder what exactly was presented and how it was presented. Now that's getting corroborated, in my opinion, by the fact that there was a grand juror who's been hearing this and saying, that's not my recollection of how the grand jury proceeded. I've been in grand juries. I've presented cases as a former prosecutor to grand jurors. And if they have a question, you should bring the evidence forth you have to answer that question, and they should be on all the possible legal violations there. They should have a vote on.
Now, Jonna, I'll come to you. What do you think are the potential next steps here? Because right now we have an attorney general saying one thing, an anonymous grand juror saying another. I think everyone kind of wants to get to the bottom of it, but how do we do that here?
Well, I think if we're going to get to the bottom of it, it shouldn't happen in a public forum per se, because normally, look, grand jury proceedings are not public for a reason, but they can be examined. And we don't know, and again, I don't know if this juror slept through the investigation. I mean, this took weeks. It didn't take minutes or hours. It took a long time. We don't know what's motivating this grand juror to come out now. We don't know what questions were asked and answered, but I do know this, and again, playing devil's advocate, if a prosecutor wants to present the crime of jaywalking to the grand jury, which wouldn't happen because it's not a felony, but work with me here, they're not going to then tell the jurors that they can charge homicide and murder or a manslaughter based on these facts. So we have to juxtapose the facts that were available to the prosecution against what the grand jurors heard. We can easily ascertain that. I hope here that no one is lying, because, Brian, this was a tragedy no matter how you slice it, but sometimes tragedies are not crimes.
All right, so it's correct, as Jonna is saying, Kirk, that the prosecutor can present facts that only support in the evidence. But at least, and this is where I had an issue with Attorney Cameron's statements. If you say that someone is justified in their actions, legally speaking, you're saying they committed a crime. But because of an excuse, we're going to let that slide. And so if he got to the point of justification or self-defense, depending on how the state presents it, he should have presented information that an assault or a homicide or a manslaughter occurred, and then presented the justification to allow the grand jury to come to that decision, not him. I've never seen a grand jury presented in that way, except for how I just described. So that's how I was confused by Attorney General Cameron's description of this. And for some reason, I think the grand jurors makes more sense based on the outcome. What were you thinking, though?
Well, you walk through the steps in a very textbook fashion, right? So unless someone committed a crime, they cannot be justified for committing that crime. So in order to discuss justification, you have to discuss what the underlying crime would have been. And certainly someone can be justified in their actions. But what you are saying is this person did fulfill all the elements of the underlying crime, be it murder, whatever the case, however they were justified. What bothers me here a little bit more, and this goes to what my colleagues have said about just understanding where the truth lies. Clearly, someone is being perhaps a little less than truthful or mistaken, is the role of the prosecutor. Now, a grand jury is not a fishing expedition, but that being said, one of the primary roles of a prosecutor is to seek the truth. And in order to seek the truth, if you're going to impanel a grand jury, you want to provide them with as much information as possible. So the prosecutor is not here just to lock people up. The primary role to seek the truth, to understand what really occurred, and certainly given the gravity of this case and all the national attention, that's where justice would be best served. I do agree also that this needs to be continued in a less than public forum. In other words, it shouldn't be carried out in the newspapers. I would love to see perhaps bar organization or whatever the case get involved to try to just flesh this out and then perhaps provide the public with a further report on the events that occurred here.
All right, Jonna, Mike, Kirk, great answers. We're going to come back with a little bit more on the Breonna Taylor case before we shift to a news story after the break. All right, so let's continue in the Breonna Taylor case, where a judge is set to rule on a motion as to whether or not to keep evidence confidential in the Brett Hankinson case. Now, that would be up until the beginning of the trial, with the fear that such information in such a public case could potentially taint a jury. Let's take a listen to the mother and the Kentucky mayor at a press conference speaking more about the Breonna Taylor case after that $12 million settlement.
As significant as today is, it's only the beginning of getting full justice for Breonna. We must not lose focus on what the real job is. And with that being said, it's time to move forward with the criminal charges, because she deserves that and much more. Her beautiful spirit and personality is working through all of us on the ground. So please continue to say her name. Breonna Taylor.
Is this settlement a reflection that the officers acted wrong? And another question, is there a reason why you added increased drug and alcohol testing of officers involved in shootings? Why was that added specifically?
On the second question, that's just a good practice for any organization to make sure that everyone is operating their responsibilities in a straight manner. On the first note, this is just an agreement that between the parties without saying anybody did anything wrong. It's just coming together with these reforms and then a financial settlement.
Okay, our last question comes from Kate Howard from the Kentucky Center for Investigative Journalism. You mentioned reform as it related to seizing money. Was there a seizure in the Taylor case? And if not, can you address why it's part of this settlement?
I think Mike, I'll give that to you.
Well, Lanita, I'll let go first. And then,
It's not an issue. It's not an issue specifically within this case, but you know, there's allegations out there, and this piece of reform is to protect the community as well as officers with any allegations as it relates to currency seizure. So now it's, as they come into contact with money, they must always have a second officer with them, and they must also, both officers must have their body cameras on until they turn to the property room. So it's not that it was an issue in this case, it's just with some of the things that were coming up.
Now, we've all kind of talked about this concept of secrecy, whether it be the grand jury and the information coming out about it. And now we're talking about secrecy in another form, that being discovery practice, which based on the state can be that you don't get information until trial or you get it much earlier. Kirk, let's bring you in on this one first. I know that you and Jonna are talking about keeping what's going on in the grand jury secret until we can finally get a final report. And now we're talking again about secrecy in the Brett Hankinson case. I would agree that in the Hankinson case that makes sense because it might taint the jury. But do you think we've gotten to a point in this case where secrecy might be a little bit hard because of the public pressure? Or do you think we should stand firm to that based on the defendant's rights here?
Well, it's interesting. There are two very directly competing interests here. So one is secrecy with regards to the defendant and the defendant's right to a fair trial. Certainly, jury hasn't been selected in the Brett Hankinson case yet, so if information is released, it's possible that could taint the jury pool. However, the competing interest directly against that is the interest of society. So there are so many question marks with this case, meaning that there are so many folks that are unaware. There's so much information out there that we don't know if it's true or not. We don't know the veracity of the information. We don't even know everything that occurred. You looked at that press conference, it was like a hot potato who wants to answer the question. So the public certainly has a right to know. And this also goes to the re-victimization of the victims and society in these types of cases where, you know, the victim is killed, Breonna Taylor, and then you have the re-victimization of the family and society by all this conflicting information. So we need to know, people need to know. Which will win out? That's the question of the hour, without a doubt.
Yeah, Jonna, I think that Kirk said it perfectly. It's a competition, not in the general sense, but a competition between the defendant's rights and that of the public. And it seems that the public's interest is growing more and more with every potential question or this. But how does a defense attorney say, hey, I see the wave of public need here, but I've got a client to represent here. How do you think the balance is going to be struck here?
Precisely. I'm so glad you asked that, because the public's rights and the public's need to know, or the public's appetite for all things salacious, should never trump a defendant's right to a fair trial, a defendant's right to the presumption of innocence. And perhaps we'll talk a little bit more about this later when we get to Ghislaine Maxwell. But that's precisely what's happening here. The public doesn't need to know if their need to know is going to upset the constitutional rights of every defendant to have a fair trial. And in this day and age, with social media, with cyber everything, with everybody getting facts which may or may not be true, let's face it, folks, it doesn't trump the defense rights. And in this case, again, I would have to err on the side of the defendant always for that reason.
True defense attorney after my own heart. I think that's that. And Mike, I know we got to switch gears, but we share a bond, Mike and I, and I think he agrees as well with Jonna. So let's just quickly switch gears and talk about another case that is equally, if not more, tragic, and that is the Jamal Khashoggi case. If you recall, this was an individual who was a green card holder in the United States. He was a dissident of the Saudi Arabia government, and he was found dead and dismembered in his hotel room. At first, they denied it. Crown Prince of Saudi Arabia said this never happened, and later on, they admitted to it being premeditated. Well, now his wife by religious marriage, not civilly marriage, because there is some distinction there in the court filings, Hoti Che Shenjitsi, apologize for the mispronunciation. She is filing suit on behalf of her deceased fiance and or husband, depending on how you're looking at that, saying that the crown prince and every and any person involved should be federally charged, because you bring this in federal court, for the death and dismemberment of her husband. Let's bring in our guests here. Mike, we'll start off with you. The major question I had here is, how do you sue a crown prince? Can you?
I don't know. That's a little bit out of my lane right now. I mean, you talk about obstacles and, security questions, national security, international security, immunity. I wouldn't even know where to begin, and I wish you would have went to the other two guests first, because I have no clue here, Brian.
All right, let me work the gambit then. All right, Kirk, give me something, because it's not just crown prince. I'm not talking about Thailand or the Queen of England. I'm talking Saudi Arabia. That just the connotation and also the denotation behind it, that he is almost untouchable in any country. How do you go after him and the people he's associated with?
Well, I'm with Mike. It's a little bit outside my area of expertise, and I'm being kind to myself by saying a little bit. However, Mike brought up a great point, that we are talking about another sovereign, another country that the United States, I'm sure we have different forms of treaties with. So this is not just a simple case where you go down to the courthouse, you file suit, and somebody knocks on the crown prince's door and serves him. Nothing can be further from the truth. There's a possibility that this suit may be thrown out because there may not be relief. There's no possibility of relief that can be granted for the plaintiff. So that's certainly a possibility. A court will have to weigh, should we even jump through the hoops to bring this to court when there is absolutely no relief that the plaintiff may be able to be granted. So I think that would be kind of the first stop on the train, so to speak. I doubt that if the prince would even defend this, probably just let it play out in the court. Yeah.
Now, I'm going to have to admit, Jonna, that I am similar to like the other guys on this panel, Kirk and Mike. I have no idea how this plays out. This is definitely outside of my wheelhouse. So I'll come to you, but let me add a little bit more. The civil lawsuit alleges 7 counts against at least 29 individuals, including the crown prince. Charges of extrajudicial killing under the Alien Tort Statute, extrajudicial killing under the Torture and Victim Protection Act, torturous interference of contract, wrongful death, and intentional infliction of emotional distress, just to name a few. Now, there's laws that this victim can point to, but again, I guess the concept becomes the person in which you're going after. I don't know if the court has jurisdiction or the ability to bring that person even into court to hear these charges. Maybe they're just going after the small fishes and naming the big one there just in case. What are your thoughts on this lawsuit?
My thoughts are 2 words: procedural nightmare. And for all of the reasons that my colleagues also said, and here's the thing, I agree that this is a case, emotionally, we want this plaintiff to recover. Her fiance was brutally murdered, assassinated, dismembered, nobody's owning up to it. I get it. Does she have standing in the real world? I don't know. But here's the main point. She may win by default. If the case does not get dismissed, and between us, it probably will get dismissed. But if it doesn't, because of that emotional connection we're rooting for her, nobody's going to answer this complaint. This is going to be a default upon default upon default. There's going to be no way for her to collect any sort of remuneration or damages or anything. So it would be a Pyrrhic victory. And but she's not going to let this go. And I admire her for not just standing down and saying, oh, well, he's dead. Nothing I can do about it. I admire her for going forward. I think it's going to be a disappointment in the long run.
All right, we'll keep a track on that. I would tend to agree. I don't see how this case gets recourse, but we'll be paying attention with a close eye. Let's take a quick break and come back with more here at the Law&Crime Report.
Maxwell was among Epstein's closest associates and helped him exploit girls who were as young as 14 years old. Maxwell played a critical role in helping Epstein to identify, befriend, and groom minor victims for abuse. In some cases, Maxwell participated in the abuse herself. As alleged, Maxwell and Epstein had a method. Typically, they would befriend these young girls by asking them questions about their lives, pretending to be taking an interest in them. They would take them to the movies and treat them to shopping trips. Maxwell would encourage these young girls to accept offers from Epstein to pay for their travel and their education, making these young victims feel indebted to Jeffrey Epstein. After developing a rapport with the victims, Maxwell then tried to normalize sexual abuse with a minor victim through a process known as grooming. For example, Maxwell would discuss sexual topics with the victim and undress in front of the victim, or be present for sex acts involving the minor victims and Epstein. Maxwell's presence as an adult woman helped put the victims at ease. As Maxwell and Epstein intended, this grooming process left the minor victims susceptible to sexual abuse.
All right, so again, we're talking about striking that balance between the defendant's rights and the rights of the community to know about what exactly this individual, specifically Ghislaine Maxwell, is being charged with. Now, Jonna, I want to feel this to you because I feel like during this segment, I am agreeing wholeheartedly with you in terms of protecting the rights of the defendant from this kind of public outcry.
Mm-hmm.
My question now is, though, I think, and correct me if I'm wrong, that the feelings towards the Breonna Taylor case and the feelings toward Ghislaine Maxwell are different because of who the victim is and how things played out, and the Attorney General and the prosecutor and whatever. But at its core, it seems that some people are picking and choosing when they feel that defendants' rights should be upheld or when they should be reduced in some way, shape, or form. Do you get a sense of reading that when you look at the Breonna Taylor case and the Ghislaine Maxwell case?
Brilliantly said, Brian. Brilliantly said. That's precisely what's going on. And unfortunately, we cannot, as a society, we risk a whole lot. My freedom, your freedom, everyone's freedom. If we're going to pick and choose which defendants are entitled to the presumption of innocence and which defendants are entitled to due process, because guess what? Each and every one is, and you might not like the charges that are facing, that Ghislaine Maxwell is facing. Nobody likes those charges. But at this stage in the game, she is presumed innocent. And from the moment of her arrest, from the moment of that presser that you showed a clip of, her rights as a defendant have been trampled on. That press conference, that wasn't a press conference by a prosecutor who is trying to fetter out potential charges. That was a press conference by a prosecutor who wants to add to the Netflix script, that should be a closing argument after all the evidence is heard. But no, this prosecution not only started this case off on the wrong foot, but Ghislaine Maxwell is still sitting in jail when every single other high-profile, equally fleeable defendant of late got bailed out. What's up with that? You're going to get me started down a long road that you probably are going to be afraid to ask. But the point is, Ghislaine Maxwell, whether you appreciate the charges, whether you think she's a monster or not, is deserving of the presumption of innocence, and she's not getting it, and she hasn't gotten it from the moment she was arrested on July 2nd.
Jonna, let me know anytime you want me to second seat a case. I'll just sit there and look pretty, it's fine. But I'm loving the energy, and I asked that question for a reason. Now, Mike Koribanics, let's bring you in here because I get it. Like, in my heart, I'm like, you know what? I want all of Ghislaine Maxwell's laundry out to be shown. But at the same time, I see how this procedurally is happening because there's no love loss for me and the allegations against Ghislaine Maxwell. But at the same time, I'm almost fearful as a defense attorney to be like, no, eyes on Ghislaine Maxwell. Don't do that same thing to my client, because if this process is turned on to our clients, how will this affect the criminal justice system?
Well, I disagree. I disagree. Maxwell was given her constitutional rights of protection. She decided to waive her Fifth Amendment right and appear in a deposition. She decided that. She could have exercised her Fifth Amendment right, and I can't believe counsel couldn't see there was potential criminal charges when she sat for that deposition, and she wouldn't have that deposition. But they wanted to have their cake and eat it too. They wanted to show what rich people can do. I'll go through the dep. We'll keep it sealed. I'll give you all some hush money, and we'll move on our way. Now, as a defense attorney, I think everybody is entitled to their rights. And she had it. This is much different than the other case we were discussing because they chose to take a chance. Her attorney said, waive your Fifth Amendment. We'll try this non-disclosure, which we all know any non-disclosure agreement will say it can be disclosed if there is legal process, if there is a crime committed. So I disagree. I think she had a chance to exercise her rights, and she decided to waive it, and she took her chance, and now she's paying the price. I think this is the proper process.
All right, great analysis, Mike. I like it. Kirk, Professor, we come to you. You're a bit of a tiebreaker here. How are you viewing this? Because Mike brings up some solid points. The Fifth Amendment right can be waived. And if it's waived, it's fair game for the prosecutor to flaunt out there. But Jonna brings up some great arguments as to the fact that there needs to be certain levels of protection. Were those protections waived? What are your thoughts?
So this is easy for me because I agree with both of my colleagues. And I'll tell you why. So first, absolutely. Bad advice to sit for that deposition. She waived her Fifth Amendment rights. I cannot imagine, knowing everything that we know now, why she would sit for that deposition. Probably one of the worst legal moves I could think of a client in this position doing. So, and once she does so, it's fair game. The other side of the argument is extremely compelling, and I'll tell you exactly why. Because this is what we have been talking about all summer since the death of George Floyd, the true and fair administration of our criminal justice system. And we cannot cherry pick between I like this defendant, I don't like that defendant, therefore, in this case, this should be exposed, in this case, it should not. So here, I think it's a very compelling argument that forget about the need of the public, forget about the heinous nature of the crime and so forth. That is irrelevant. Let's focus on the procedural, well, it's kind of the semi-procedural aspect of whether she actually waived her rights. And if she did, it's fair game. But all those other things, no. Fairness is what's important. That's what separates our system of our criminal justice system from other criminal justice systems around the world. The fact that a defendant, no matter who he or she is innocent until proved guilty and judged guilty by a jury of their peers.
All right, let's listen to
you're both right.
Wait, what about me, Kirk? Come on, can I be a little right too, Professor? Come on.
You're always right. You're always right.
All right, so let's listen to a little bit more of the acting AUSA during that press conference, giving a little bit more about Ghislaine Maxwell's case.
That abuse included sexualized massages during which the minor victim was fully or partially nude. These sexualized massages developed into sexual encounters for which Maxwell, in some instances, was present and participated. Maxwell and Epstein worked together to entice these minor victims to travel to Epstein's residences, depicted on the other chart at the front of the room. His residence in New York City, on the Upper East Side, as well as Palm Beach, Florida, and Santa Fe, New Mexico. Some of the acts of abuse also took place in Maxwell's residence in London, England. In addition to allegedly enabling and participating in the sexual abuse of young victims, Maxwell compounded her crimes by repeatedly lying in 2016 when she was questioned under oath. And we have charged those lies in 2 perjury counts. Maxwell lied because the truth, as alleged, was almost unspeakable. Maxwell enticed minor girls, got them to trust her, then delivered them into the trap that she and Epstein had set for them. She pretended to be a woman they could trust. All the while, she was setting them up to be sexually abused by Epstein, and in some cases, by Maxwell herself.
All right, so Mike, let me come to you with this one question before we take a quick break. Is this letting too much out of the bag for the prosecutor. I know we've had this conversation in the past about these press conferences and how much do you give? I don't know where that line is. Where is it for you in this press conference?
Well, Brian, as you know, I do a lot of federal work, and they hold the evidence till the very end or before a trial. Me, I love when prosecutors talk. Let them talk all they want, because now they're giving me a preview as a defense attorney as to what I need to prepare for and where they may be on the wrong track and where they may not be. So they have an obligation to inform the public of the charges in the document. So there's certain things, we don't operate in a secretive justice system. The only people who have the right to remain silent are defendants, and there's a responsibility to inform the public of charges. And they always say defendants are presumed innocent.
All right, so we'll see how this plays out. We're going to take a quick break and come back with more here at the Law and Crime Report. All right, so our final story here at the Law and Crime Report deals with homelessness and the mayor of Minnesota being sued by 7 complainants who are saying that Mayor Jacob Frey cleared out their encampments without notice during the midst of a pandemic. Now, prior to this, there was some ordinances that allowed for the making of these encampments for homeless people based on the coronavirus pandemic. It appears that based on their complaint, though, they're saying that they were moved out of these encampments without the proper due process, and a lot of their items were destroyed and or lost altogether. Now, let's begin with Kirk. When I read this, and I have to admit, I haven't heard or looked at the taking clause since 1L year, and it's beyond rusty. I heard a little bit of resemblance or some analogous arguments to the taking clause that, hey, if you're the government and you're going to take my property, you've got to give me notice and you've got to give me reimbursement if you do so. Are there any analogies here, or am I completely off base? And what were your thoughts when you heard this lawsuit?
No, it certainly sounds somewhat analogous. Brian, you're referring to the taking clause of the Fifth Amendment, where the government may not take private property for private property for public use without compensation. And it has been interpreted to hold that when the government does so, they must give proper notice. And what the litigants here, the plaintiffs, are focusing on here is the notice and the destruction of their property, right? So that they're claiming they weren't given notice. So we have to take a look at the court documents in order to determine that. But there certainly is a very substantial public health interest. And we've seen this historically all over the country with regards to urban kind of communal, ad hoc communal encampments like this, where they tend to be kind of hotbeds for all types of health issues. And that gives the government the right to move in. So, but this is all about notice. They're claiming you didn't tell us, you came in the middle of the night and took our stuff. The other issue is, of course, the argument will be for the government is the reason why they tend to do these types of things at night is to ensure that there is no riot or conflict or, and so forth. Usually you come during the middle of the day, the cameras come out, it turns into a very ugly incident.
Yeah, and John, I was going to kind of lead into that as well. This seems to be just strictly a notice issue because from a factual standpoint, the government seems to have a pretty strong leg to stand on. They're saying this is a hotbed for disease, specifically the coronavirus. This is a hotbed for crime, and it's also just not safe in general to have these encampments grow to a certain volume. Right. Factually speaking, it seems like the government has a pretty strong position here. What are your thoughts?
Well, let's define what is proper notice. Was there an ordinance that expired and they're presumed to have notice? Did somebody get on a bullhorn and say, hey, folks, you got to move it out at midnight tonight? I mean, how did these people get? I don't think the government needed to have a process server serve each and every tent and make sure that each individual knew that they were going to get moved out at some point. I mean, and I'm not making light of this, but let me just tell you a quick story. When I was in law school, I had the government take my car several times because I didn't pay my parking tickets. Nobody gave me notice. They just took it while I was in con law. I mean, numerous times. So the government is able to take private property sometimes, and you have constructive notice if you don't have actual notice. And my guess is that'll be part of the defense here.
I can just imagine you, Jonna, coming out with your con law book and just being like, no, I've got the page here. You can't do that. You can't.
Right. I had the book. I didn't have the money to pay the parking tickets. That was then.
Fair. So, Mike, let's say hypothetically speaking, The government didn't give them proper notice. What kind of recourse are we talking about here? Are they buying new tents for them? Are they putting them up somewhere else? What's the recourse that these guys could likely get if they are on the right side of the law here?
Well, that's an excellent question. And, you know, it goes back to there's no simple answer for complicated questions. I mean, we're in the middle of a pandemic. People are just trying to survive. The government's trying to help in some way with setting up these encampments. Obviously, they found something that is not safe about them. You know, today has been, it seems this whole show, we've been talking about balancing, you know, and I think that's pretty problematic in the times we're in right now is you can only have balance if both sides move. That's how you get the scales of justice to come out equal. But if one side sticks to their side and the other side sticks to their side, there's imbalance. There's no movement. So I just hope they could safely put these people who don't have homes and are in need of help in a safe place. And I just hope that the government did the best they could to give notice and balance the health issues.
Yeah, and that's the I don't want to call it an elephant in the room. It's probably the whale in the room is that much bigger. If the coronavirus pandemic wasn't occurring right now, there may not be such an issue or so large of an issue as to having these encampments because you could place individuals as they are in other cities in different locations. You can put them in homeless shelters, but you can't do that right now because of the pandemic. Kirk or Professor Burkhalter, is this a situation where it's just like, you know what, we've got this virus and we're just doing the best we can, and I'm sorry, guys, we've got to break this up? Do you think that's going to be an argument that might be floated out here?
Oh, it certainly could be. I mean, we are in the middle of the worst pandemic arguably this country has ever seen. So and I'll tell you, we are very fortunate that we don't hear this argument more often. That we're in a pandemic. This is the best we can do. But in this particular instance, absolutely. And there are hopefully other resources, as far as, what type of relief can be granted, perhaps other types of more permanent housing or shelters or whatever the case. But the fact that we are in a pandemic, people are dying. We're almost at 250,000 people dead in this country, and 8 million people have had this disease. Absolutely, I could see that argument trumping many other arguments.
Now, Jonna, I'm going to do something that I hate that people do on TV. They throw out this word all the time, unprecedented. But I think it kind of fits here. This is unprecedented. We've never had this situation during a global pandemic with the numbers that Kirk put out there. Is this new legal road that we're just going to have to walk because of what we're surrounded with, it's kind of hard to really tell where we're going to go from here?
My guess is, yeah, that's precisely where we are, because we have not experienced this before. And we have to. And the one thing that I agree with our colleague Mike on is that we do need balance here. And it's very hard both sides have to move because we have a public health issue and nobody wants to just, kick somebody who doesn't have a permanent place to call home to the curb and say, sorry about your luck. We do need a balance, but we need to keep everybody healthy. And we also need to keep in mind the people who want to utilize the parks that the taxpayers pay for safely also have a right to that. And I agree with Mike. It is all about the balance. And because this is unprecedented, we'll see what the courts are going to do with it. I don't blame these people for complaining. I really don't. But they have to also move if we're going to get balance, figuratively speaking, I mean.
Of course. And it makes a lot of sense. I would tend to agree with the balance argument that's being made here. Maybe it's the Canadian deep in my heart. I'm like, why can't we all just win? Why does everyone have to lose in order for there to be compromise? But that comes from that, I guess. We got a few moments. I want to thank you all for joining us, lending us with your expertise as always. I know that you're from different parts of the East Coast right now coming in. We'll end with this, though. If this does happen and the government does win, what happens with these people? Do they just get shuffled somewhere else, Kirk? What do you think is going to happen if the government wins then?
Well, I agree with you that, and I teach my students all the time, that it is possible, as crazy as it seems, that everyone can win. Everyone doesn't have to lose. You don't have to beat your adversary in the ground. So in other words, if the government wins in court, I think the government does have a responsibility to assist and help these folks find housing and shelter and medical attention, whatever they need.
We'll hope that that occurs. Again, thank you all for joining us, and thank you for coming here to Law and Crime Report. That's it for today. We'll continue our regular scheduled program. Have a nice day, everyone.